based on the marks obtained in the practical. It applies only to ITA candidates and the candidates who have the national trade certificate qualification. For those candidates, it is not necessary to subject them to class. The results will be declared based on the marks obtained by the practical examination. The order will be effective so and so and will be applicable retrospectively to ITI passed candidates who have been cleared the practical ATT exam but not cleared this so and so. But be that as it is. This your option to decide that my respectful submission is that there are, as I mentioned, 21 regions in the country notified these vacancies of 32,000 people. More than 84 lakh people have applied. Though 108 applications, 1 crore 8 lakh applications applied. Delay was made. I filed on board also and see. But so far as the and just note this.
Yes.
So far as this second private railway region where these people applied, the total 1,642 vacancies are notified. And out of that, 9,61,263 candidates applied. And more than 5,28,069 candidates appeared for the examinations on different dates, which were for December 25 and February 26. And my respect was sufficient. A submission had been made by the petitioner. In the event of calculation of the marks, they are saying that some dichotomy between 2022, post 2022. That does not, at this stage, results of the main exam itself are not declared. Kindly come out with a notification. Now, this is not by considering the jurisdiction of this honorable court. It is just to say that there are no prima facie. Kindly come to paragraph 12 of that notification, which is at 57. That this relates to Railway Act Apprentices. You will also find that to paragraph 12 at page 57.
Yes.
Right. If at all that this notification, if they have any opinion, they should have charged before the tribunal at a proper state and the notification. Even this also doesn't come to the disadvantage. It is a clear case of apprehensions and see 12.4. The course completed Act Apprentices will be given due weightage for the marks obtained in the National Council vocational trades. It says that whatever you got marks in that test will be given due weightage examination, and such that 1/3 of the marks in the preparation of the final merit. So 2/3 will be written examination merit, and 1/3 will be for them merit list. After conduct of CPD shall be based on the marks obtained in the National Council repeated. The next one is important. In situation where the marks obtained by adding the NCTU score is less than the marks obtained in the CPD, then the higher or best of the two marks will be considered for these people. The course completed apprentice will be exempted from the physical efficiency. The course completed CCA, trade, railway should upload their details of solution. The candidate fails to clear the solution. My respectable friend, a combined reading of 12.4 and 12.5. What it says is that the note, because we can't do anything now, even tomorrow results are declared. It has to be only strictly in terms of 12.4. 12.4 is not in question before this court. They say that they doesn't read how that it disadvantage to them, except orally saying all these things. But we enjoy not when my friend argues, he puts the question on my behalf and he also puts the question, answer also from his side. We appreciate that argues my friend is having it. But the reason is this one. Combined reading of 12 and because we are bound by the what we said in the notification, assuming for a minute whether it is or not. But my respectful submission in so far as the interim prayer is concerned, totally beyond the scope of main prayer sought in the questions. Notification is not under charge. It cannot be charged before this court. And they have remedy in the earlier case when the notification has come. But now saying that alternative they want 20 is absolute. We never agreed for 20. We said you come under 20 category. And that is against 32,000 people. In so far as this region is concerned, both and further. I pray that this a year filed by them for interim prayer shall be dismissed. But leave the question main prayer which so far as that is going, they are going to defend it. And the counter had been filed and this was the third response. He said that because he is the officer railway speaker. Now they included the general railway. But what I respect is they understand that I have seen the they understand which region they are from. They can't find here. But seeking this relief which affects the throughout the country. Exams are over. It has 3 stages for document verification, everything. But I pray that the immediately the interim order certificate. I have filed by them.
I have to 3 questions of what my learned friend said. My lord is replied to it. I will restrict myself subject to my learned friend completely. My lord, we can prejudice the mind of the court. That's also an art. I will have to learn it from my learned friend. Kindly see something.
Since I complimented, this is the reverse compliment I have taken from you.
Both will have to
Whether it's a compliment or not, I have to introspect.
Because I shooting further.
Really compliment.
Kindly see the first submission, my lord. I will go in the reverse order. See page 57.
I'm sorry, one more aspect.
Yes, yes.
Just wait. My friend had brought the words to 86 also. 96, what let us in the northern region. It doesn't relate to recruitment. It is at the time of entry as apprentice. Kindly come over there. It can't be connected to any of the issue here. Preventive check of conducted regarding the engagement of apprentices under the Apprenticeship Act. At the time of entry into that, there is a railway board circular. I have seen this letter. There is a railway board circular issued in the year 2015, where they said that whenever they receive the application for apprenticeship, it has to be scrutinized by a committee consisting of so and so officers. And also there is a methodology in that so far as the processing of the applications for the admission of these apprentice courses. Since those mandate of the railway board circular has not been complied in those cases, can we just see that? It has nothing to do with either the proceedings of 25th January or this one. With reference to this, it stated that the preventive check vigilance has been conducted regarding the engagement of the apprentices under the Apprenticeship Act, engaged in Western region so and so. The irregularity found during the check period is the merit list candidate should be by, as I mentioned, by junior scale committee members prior to so and so. This was not complied there. The second one is also not. As per the statistics para 2, railway board circular number so and so state that a merit list would be prepared by a committee who will be then place the result before the head of the working shop. So what they requested ultimately, you shall comply with the mandate of the railway board circular when you are considering the applications for the entry into the apprenticeship. We are not in the stage. This is after the 2022 order is in question for 25th January order. That relates only to ITA candidates and national certificate holders who are specified there. And for after 6 years, they did not solve that order is not under suspension or any interim relating to that is not paid. They want straight away omnibus way of staying the results throughout the country.
Take your losses to 57 first man. Why we are before court, your losses would appreciate that. 1-4. There is some dichotomy. It's not the correct sentence that's liable to use. It is dichotomy. ITC 12-4 once again, madam. The course completed at apprentice will be given due weightage for the marks obtained in the national vocation test examination. Such that 1/3 of the marks in the preparation of final merit list after CPT shall be based on the marks obtained in the national vocation test. Previously, this national vocation test comprised of a theory trade paper for 100 and practicals for 300. Now you have done away with that 100 business. So it is only 300 plus sessional training of 100 marks, 400 marks. Now kindly see 86. It is not for entry as an apprentice. It is for engagement of apprentice. Kindly see 86 for one more moment.
Yes, sir.
Paragraph number 2, 3. I am sure my learned friend would not be canvassing that for a person to enter into apprentice, the railway conducts a written examination, etc. So therefore, this has to be understood in a different prospectus. Kindly see paragraph 2 at page 86 for one moment, my lord. It is further found that the paper setter and evaluator for the exam are done by the supervisor staff. There is no such provision under the railway rules wherein the supervisor can be assigned such roles. The paper setter and evaluator, etc., should be at least junior scale officers. The marks and attendance of the candidates are uploaded on the apprentice portal, etc. immediately. The access should be restricted to one person. Then after completion of the examination of railways, the marks are uploaded on the website for which certificate generated from the apprenticeship portal. No approval of HOD is required. So all these talk of after completion of training, not entry into apprentice. This is one thing. And second thing is, my lord, the second aspect which I have to reply is 20%, 21 centers. You have applied for Southern India, you have applied for Kashmir. They are totally irrelevant. In as much as the prayer was, your lordships would be agreeing with me, for an unemployed person, place of his normal residence will best jurisdiction in the High Court where he can knock the doors of the court for the redressal of his grievance. So, all the persons who are now petitioners before your lordship are within the territorial jurisdiction of this court. And they pray, I may have applied for post in Punjab. If I have a preference, I may apply. But as of now, I am not an employee in Punjab. As of now, I am not employed in Southern region. I am only a person unemployed applying from Hyderabad. Therefore, within the territorial jurisdiction of this honorable court. This is the precise reason why I said we need to get that act also, saying that he applied for Southern region. And the third aspect which my learned friend read to your lordship, the 2019 order of the Honorable Central Administrative Tribunal, that's a case where their names were included, subsequently deleted. Consequently, the DGP order was not in challenge there. My inclusion in the panel and removal from the panel was a subject matter of challenge. Therefore, the counsel for the petitioner who incidentally filed this rightly went to that court. The counsel for the petitioner who incidentally filed that court came to this court specifically. Expected of a model employer. We are no longer model employer. If they say we can't help it. But question is, will you not address that question first? Does it not mean that your anxiety is to get the post? And kindly see the
ticket application has been filed under the third respondent only. Keep it open for internal application filed by the respondent. Yes, pass orders. So for IAS are concerned,
yes.
IAS are concerned. I will pass an order. Leave it open for the for filing counter on behalf of
unless the DGP let us come, your lordship cannot find it.
Because interim orders to the extent of respondent three only they file a counter. You will pass orders to the extent of the wicked application of counter. It is open for the Marsim Sharma for file of counter on by the first respondent.
The judgment of the division bench of the Honorable Court held in first court relating to 2019 selection, where also, my lord, the DGP has not issued certificate. The court they came to this court and said certificate will have to be issued and consequently appointment will have to be allowed.
What is it?
This undertaking, what they're saying is the petitioner in RRB petition undertakes that he shall not alienate, encumber, transfer, or create any third-party interest in all the properties which are mentioned in the request. That is exactly the purpose of attachment.
For his satisfaction, what is this, sir? I do agree.